The eviction process in Colorado is a legal process. Once again, a landlord cannot evict you by changing your locks and kicking you out. They need a court order in order to remove you from the premises. It starts with a notice to quit. The landlord will serve you a notice, and it would include all the reasons why he thinks or she thinks you should be evicted. So that could be for non-payment of rent, that could be a minor lease violation, etc. You have 10 days to fix. It's called a cure period. So if it's for a minor lease violation, if you fix the issue, you can't be evicted. If it's for non-payment of rent and you pay the money you're owed within 10 days, you can't be evicted. So let's say if your lease doesn't allow pets and landlord serves you notice to quit to remove your pet, and you do so within 10 days, landlord cannot evict you. If you cure during that period, you are safe. So it starts with a notice to quit. If 10 days pass and you don't cure, if you don't fix the issue that it alleged, then the landlord has to file what's called a complaint with the court. In the complaint, it'll outline all the reasons why a landlord thinks they can evict you. The landlord files a complaint with the court. They must personally serve you a copy of that complaint. And along with that complaint, they must serve you with a summons. And the summons essentially says that you need to be at court on this date at this time. You must be given at least 7 days from that date until your court date. It's very important that you go to that court date. If you don't, a default judgment would be entered against you. And it doesn't matter what reason or defense you have against an eviction, a default judgment is basically game over. That's the end of the case. So it's very important that you go to the court date listed on the summons. So you go to your summons date. So you're at court, and what do? You have two options. First is file an answer. An answer is basically a response to the complaint. So there you would assert any legal defenses you have to the eviction. It's very important to consult an attorney before this point because they can help you identify any legal defenses you might have. Your second option is entering what's called a stipulated agreement. A stipulated agreement is basically both parties entering into a contract resolving the dispute. Both parties say they'll do X and Y, and in return, the case will be dismissed. Once again, it's important to consult an attorney before you sign a stipulation because you can be signing over important legal rights in that stipulated agreement. If you file an answer, what will happen then is a court will set a hearing date. At the hearing date, it's the landlord's burden to prove that you violated the lease and you should be evicted. If they don't meet that burden, then it will be the end of the case and you won't be evicted. Once again, contact an attorney. They can help represent you at that hearing. However, if the landlord meets the burden and you are evicted, they'll enter what's called a judgment for possession and will issue a writ of restitution. That writ is what the sheriffs need in order to conduct an eviction. Without a writ, you cannot be evicted. If you're on Section 8 housing, an eviction can revoke that voucher for Section 8 housing. If you're worried about being evicted, contact an attorney. Contact them as soon as you get your first notice to quit. Contact them if you have a court date. The sooner you get an attorney involved, the better. There are organizations that will help you pro bono. Those include the Colorado Poverty Law Project, Colorado Legal Services, and Colorado Housing Connects.